and whether they do so fairly, without bias, and without increasing conviction rates or sentence length. And if they do not deliver on all these points, will he think again?
Justice Secretary.
Well, I'm very grateful to my right honourable friend for all of his work in these areas. And yes, I can commit to that evaluation, which is, of course, very important indeed. And it's right to say, too, that Sir Brian found in his report, or estimated that he suspected there would be 20% faster, because, of course, it does take time for juries to deliberate, and without the necessary conveyance of information between barristers, the judge and the jury, he expects a system that's judge-led, or indeed that's magistrate-led, to be speedier. He will know too that the Magistrates' Court don't currently have a backlog, and with increasing magistrates can do a little more.
Jess Brownfield, the Liberal Democrat spokesperson.
Thank you, Mr. Speaker. The announcement today of the Government's plan to reduce the use of trial by jury would be an historic upheaval of our court system with profound consequences. But the Justice Secretary has not stood up and argued in favour of judge-only trials on their own terms. Instead, he has made arguments that there is no alternative. That is simply not true. We have heard many within the legal profession argue that removing trial by jury is a misdirection for the multitude of problems that are actually underlying the backlog. These problems, caused by years of Conservative mismanagement, have resulted in countless wasted hours of sitting times, and victims failed time and time again. Perhaps the defendant does not arrive in court due to the broken private contracts. There is no interpreter. Maybe the witness care unit forgets to tell witnesses to attend, or key evidence isn't served until the day of trial, so the defence has no time to consider it, or there's not enough court staff to manage the security on the door and the trial runs late. Or our crumbling court infrastructure results in no running water, a broken lift, even flooded courtrooms. So we do need a real solution to tackle these issues which plague our justice system. But instead, the Justice Secretary intends to remove a huge number of jury trials despite his own previous opposition. All while the Ministry of Justice capital budget is being cut by 3% in real terms every year. So while I absolutely welcome the £500 million investment in victims and witness support over 3 years, the total courts maintenance backlog is estimated at £1.3 billion. So can I ask the Justice Secretary, where is the investment to fix the collapsing infrastructure in the justice system? And will he consider reopening many of the Crown Courts closed under the Conservatives, including mine in Chichester? And as he confirmed to the media today, an entire jury's worth of prisoners have been released in error in recent weeks. Does the Secretary of State have confidence in his department to oversee such an extreme and radical reform when they're not even getting the basics right?
Justice Secretary.
I'm very grateful to the Right Honourable Lady. She mentions a range of issues which are important to ensure that across our 80 or so courts and 500 courtrooms that they're working effectively, and that's why we've asked Sir Brian Leveson to look at efficiency as part 2 of his review, because we do need not just our courts but Crown prosecution, our police, working together at a regional level to deliver that improvement. I would just say to her that when we're thinking about those either way cases, I do think it's legitimate for the government to take a view on, for example, whether a driving licence fraud or fly tipping or the theft of a bike requires a jury trial, which will last 2 days, let's say, or actually it can be dealt with by a magistrate or by a judge. And I know that she is committed to us bearing down and dealing with violence against women and girls. And it can't be right that if you're charged with an offence like the theft of a bicycle, theft from a vehicle, theft from an employee, that you can opt for a trial, and by necessity that goes into the system and will delay a rape trial, a murder trial or something else. That's the balance of decision that I've sought to make, and I think it's why the government has made the right decision, implemented Sir Brian's reforms.
Dame Diana, Mother of the House.
The entire House is concerned about victims, including attacks on women and girls. But the entire House is also concerned about the men and women who will undoubtedly suffer miscarriages of justice if the right to trial by jury is curtailed. And I would quote from a lawyer: "The right to trial by jury is an important factor in the delicate balance between the power of the state and the freedom of the individual. The further it is restricted, the greater the imbalance." That lawyer is our current Prime Minister. He wrote that in 1992. It was as true then as it is true today. How can the Chancellor stand up and propose a limitation of the right to trial by jury when he knows perfectly well the category of defendant who will suffer the ill effects of that?
Justice Secretary.
Can I say I'm very grateful to my right honourable friend, and I'm hugely grateful for her expertise in these areas. She will know that for lots of reasons to do with poverty particularly, many women are affected by by criminal cases that don't actually command a sentence of much more than 12 months. Actually, the vast majority of crimes committed by women are dealt with by magistrates. And it's my judgment that they could do more. And I do say, in keeping in mind the victims particularly, it cannot be right that we're asking women to wait. That in a city like London, if you are raped tomorrow, the listing will not be until 2028 or 2029. If you're centring those victims, and it's why I think the Victims Commissioner is supporting these changes, it is because we are putting those women first. I'd also remind her of the 550 million that I'm dedicating to victim support to support those very women she talks about.
Sir Jeremy Wright.
Thank you very much, Mr. Speaker. I think the government deserves credit for taking seriously a serious report into a serious problem. But can I ask the Secretary of State whether it is his preference that the changes he's outlined to jury trial are permanent or will recede when the problem of backlogs recedes? Can I also ask him, in relation to judges alone deciding either way cases, he knows that Sir Brian's recommendation is that the presumption should be that for cases where the sentence may be 3 years or less, that it should be a judge-only trial, but that, of course, is a presumption that could be rebutted. Is it the government's intention that that should be a presumption, not a definitive rule? And finally, he knows that Sir Brian also recommended that the plea hearings be pushed back to allow for advice on guilty pleas to be given more clearly and more fully, and that is likely to increase the number of guilty pleas, preventing cracked trials. In what he's said about extra funding for the criminal bar, will he focus that funding so that people can be advised early and we can avoid those cracked trials?
Justice Secretary.
We will consult on how we implement that so we can deal with those cracked trials. I'm pleased that he recognises the importance of Sir Brian's work and his deliberations with his panel, it is not my expectation that these rules would change, and that's also because Sir Brian reflected on the complexity and the demand that we're seeing in our criminal justice system. I know, with his tremendous experience, DNA evidence, phenotyping, the range of new laws that this Parliament is introducing, the increase in sexual crimes as a result of smartphones and other technology, all of that requires change in the system. So I do believe the changes that we are making will be permanent.
Mr. Speaker, I understand that my right honourable friend has inherited a disastrous situation in the criminal justice system. Huge backlog left by austerity from the party opposite, so we have no truck with them. But does he fear, as I do, that restricting trial by jury will put a certain class of people in judgment over the rest of us, and that the check and balance on that is that the jury can be drawn from amongst what we might include working class people, as I would describe them? Does he fear that we're going to create an us and them in the criminal justice system by taking away people's right to go to trial by jury?
Justice Secretary.
I do understand my honourable friend's anxiety, of course I do, but I would just remind him, Mr. Speaker, that the vast majority of these individuals will be tried by magistrates. And that historic system that we've had is actually an aspect of that Article 39 Magna Carta right which is being tried by your peers, because they are people that live in every neighbourhood in our country and volunteer their efforts very importantly.
Sir David Davis.
The Secretary of State, when he took office, swore an oath of office. It reads, "I do swear that I will respect the rule of law, defend the independence of the judiciary, and discharge my duty to ensure the provision of resources for the efficient and effective support of the courts." Now, that last bit matters. Governments of his party, my party, and before they get too sanctimonious, the Liberal Democrats too,
oh, surely not,
all starved the courts, all of them, from Blair to now. And what he has to do is put that right, because if he doesn't get sufficient extra sitting days, this problem will not be solved. And when I say sufficient extra, it's not 1,000, it's not even 5,000. It's an order of magnitude increase, because instead what he's doing is undermining a bulwark of our Constitution. In the words of Lord Denning, it's been the bulwark of our liberties for too long for any of us to seek to alter it. So why won't he go and have his argument with the Treasury and solve this problem properly?
Justice Secretary.
I do understand the spirit of what the right honourable gentleman is saying, and he's right. Our courts have been starved of funds for too long. But he knows, despite the extra investment that we're putting in and the investment that we got in the spending review, new courts at places like Blackpool, it will take a considerable time. And I say to him, when we've asked Sir Brian to reflect, and he is one of our most eminent judges, would it really be right to ask the victims to wait a decade until we fix the system? It can't be. For all of the reasons that he reflects on in his report, we have got to chuck everything at it. More investment, which we are doing, reform, which we are doing, modernisation, which we're doing.
Which we got Dr. Stella Creasy.
Thank you, Mr. Speaker. Any of us who have supported a constituent who is in a rape trial will take no lectures from the benches opposite about how they managed our courts. There is clearly a challenge here. I think the worry for many of us is whether the Justice Secretary's own prescription is the solution, because as he points out, juries are involved in less than 3% of all criminal cases. So it is difficult to see how this measure, with all the challenges that it may bring for justice and fairness, particularly for some of our minority communities, will address that backlog. Lord Leveson himself pointed out increasing sitting days wouldn't be a solution unless we had the barristers and solicitors. So can he make a guarantee that there will be the funding for the legal aid that is required to ensure that every defendant has decent representation?
Justice Secretary.
Well, I'm very grateful to the Honourable Lady, and I just remind her that we are increasing that uplift to barristers and their fees, 34 million. We've also increased legal aid, 92 million for our solicitors, and because we do need a pipeline of criminal lawyers, we've got this match-funded scheme for pupilages, so that we do see the next generation of young people from all backgrounds becoming our criminal legal aid lawyers.
Blair.
Thank you, Speaker. Juries are not the cause of the court backlog. If they were, we would not see similar extended delays in the magistrates' courts, which have a record backlog of 361,000 cases. The cause is not just pupilages, but also legal advisers in the magistrates' courts. Given that some of these cases with potential longer sentences will move to the magistrates' court, what additional investment will go into them so that we don't just see the problem move from the Crown Court to the magistrates' court and see victims wait just as long there?
Justice Secretary.
I say that's why we're putting money into legal advisors. That's why we're growing the magistracy. There isn't anything like the backlog in our magistrates' courts that exists in our Crown courts. So the question is, should we leave it as a year, or could our magistrates do more? And I think 18 months in terms of the sentencing threshold is right.
Richard Burton.
Thank you, Mr. Speaker. I need to be honest. The prospect of citizens in our country being put away in jail for up to 3 years without the benefit of a trial by jury sends a chill through my heart. I'd also gently say that no government should ever govern as if it will be in power forever. The front bench denounce members of Reform as being Putin's pals. I think that's a fair description. Doesn't the Justice Secretary want to think again because what would we imagine if Putin's pals, as described in government in this country, where people get put away for 3 years without trial by jury, how would they use this? And isn't that a frightening prospect when we make these changes under pressure and hand these changes on to forces which I think will take things even further? Doesn't that concern the Justice Secretary?
Justice Secretary.
I would just say to the honourable gentleman that clearly I think he would accept that justice isn't being served now. And I simply would not equate either our magistrates or our independent judiciary to anything like what we see under Putin's Russia.
Dr. Neil Shasrihat.
Thank you very much, Mr. Speaker. Nobody would disagree with the Lord Chancellor's diagnosis. The criminal courts are in crisis. It's the treatment that is in dispute. And the question is whether the watering down of jury trials will be the solution, when in fact it's a lack of judges, it's a lack of court space, it's a lack of infrastructure and inefficiencies in the system, and crucially it is a lack of appropriately trained defence and prosecution counsel who can deal with the complexities of these cases. Is this not a case, Mr. Speaker, where the government have chosen to prioritise other areas of spending, such as welfare, over our court system?
Justice Secretary.
I just say to him that his party didn't come up with any solutions, and the backlog continued to rise. We commissioned an independent review led by one of the country's most eminent judges, and we are now, having reflected on that review, getting on with the business of recognising what he said, which is there is not a silver bullet, we have to do it all, and we are building on the reform he asked us to do.
MacDonald.
Can I welcome the additional money for the criminal aid advocates and also more pupillage? But if we are to rely more upon single judges and often sitting in alone, is there a need for greater transparency with regard to the selection of those judges, even to the point of individual selection on individual cases? I've written to the Secretary of State this morning on behalf of a number of our members about a particular instance of a disappearance of a judge. I'd be grateful if we could read that letter, and possibly we could meet with a group of MPs concerned about this matter.
I will read that letter and commit to myself for the Minister of State meeting with him and the MPs. And he's absolutely right. Transparency is core. And when I looked at this in the Lammy review, I was very concerned that too often what happened in our magistrates' court, what happened in our Crown Court, there were not the transcript, it was not easy. And that is absolutely part of what we are now investing in, particularly with AI as technology, and we will be coming forward with.
Liz Sutherland.
I rise as the co-chair of the Justice Union's parliamentary group. Carnarvon Justice Centre is only 16 years old, but the roof leaks when it's raining and the heating doesn't work. So I'll list some of the root causes why criminal courts are processing fewer cases. High workloads, staff shortages and inexperience, poor administration, crumbling buildings. So how does he think that undermining one of the basic tenets of English and Welsh law is going to be a solution to those problems?
Justice Secretary.
Well, can I refer her to paragraph 9 of Sir Brian's review, where it says, it is important to underline that greater financial investment on its own, without systemic reform, cannot solve the crisis. We are investing. It will take time. It's not fair to ask victims to wait.
Lindsay Farton.
Thank you, Mr. Speaker. Mr. Speaker, I spent 2 decades working on the front line in the criminal justice system, and I can tell you now, this is a crisis that has been building for years and years and years. I spoke to one of my former colleagues today to ask him how things are, and he said, something has to be done. The backlog and delay is distorting the justice system, and people need to wait so long for justice that defendants are pleading not guilty in the hope that the case ends up being considered not in the public interest. Meanwhile, the public, victims and witnesses pay the price. Justice delayed is justice denied. My former colleague is there right now working on the front line in the criminal justice system. So let's support those people working on the criminal justice system, and let's support our victims of crime so that they get justice quickly and fairly. And please be bold is my request to the Minister, and thank you.
Justice Secretary.
I'm very grateful to the Honourable Lady who puts her remarks so well. Let us be clear that there are defendants gaming and playing the system. And if we continue to allow them to do that, it is victims, vulnerable victims, who pay the price in the most serious offences in our country. That is why it is not just about financial investment. It has to be about reform. And I'm determined to see this through. Very grateful.
Thank you, Mr. Speaker. Sir Brian Leveson made a number of recommendations in his report to reduce the Crown Court backlog, many of which are welcome, but curtailing the right to a jury trial is not one of them. So will he instruct his department to publish the modelling they will have undertaken, so we can see how much effect each individual recommendation will have in tackling the backlog, so this House can take a view on its efficacy before we vote on his legislation?
I cannot say that there will be an impact assessment at the point of legislation, of course.
Cox.
Thank you, Mr. Speaker. The governance of jury trials has changed quite considerably over time, dramatically so in the 19th century and again in the 1970s. In both cases, in order to enhance and improve public access to justice. Would the Lord Chancellor agree with me that if our traditions, including our legal traditions, are to endure, they need to adapt?
Yes, Secretary.
She's absolutely right. Demand is soaring. We're asking our police to arrest more, quite rightly. All of us know. Smartphones, DNA, phenotyping so that you can tell if someone's got what the colour of their eye is, all of this stuff increases the workload. We have to reform the system, or we will break it.
Ray Matthews.
Thank you, Mr. Speaker. Justice delayed is indeed